Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott Talks Law, and in this episode shall be talking about character evidence under evidence law 2. So character evidence is covered from section 55 to 58 of the Evidence Act, 55, 56, 57 and 58 of the Evidence Act. And according to section 58 of the Evidence Act, it has not given character evidence a specific definition, but it just says that character evidence involves both reputation and disposition. So character evidence has not been given that specific definition, but it just involves that reputation and disposition. So we are going to look at how character evidence applies both in criminal and civil proceedings, whether or not character evidence is admissible in civil and criminal proceedings. So reputation, under reputation disposition, reputation this refers to that picture painted by people about someone. So that is the people's view or the public view about that particular person. So the public can view someone in different aspects. A public can form a good picture of you and can also form a bad picture of you, and reputation is just about what people view about you. Whereas disposition are those natural traits, those natural instincts that you are born with them. They cannot change, they are unchangeable. You just inherit them, and they are those qualities that are permanent, that define a person. So disposition are those traits or qualities that define a person who is, and they are real qualities that don't change. You cannot change them, they just genetic in nature. So character evidence cannot be administered. As a general rule, character evidence is inadmissible, but you have instances where the character evidence can be administered. So Phipson says that it's not wise or fair for court to rely on character evidence in making judgments, because it will lead to miscarriage of justice, because people tend to speak good things about themselves. No one wants to speak negative things or vices about themselves. People want to speak their virtues or their good qualities. So it will not be wise, according to Phipson, for the court to rely on character evidence in making judgment, because it does not resolve around the entire facts in issue, because character evidence is just evidence of people's views, opinion, if it is about reputation. So in civil proceedings, character evidence is inadmissible. Character evidence cannot be administered in civil proceedings, but you have exemptions where character evidence can be administered. These are in cases where the whole character resolves around the facts, and if the character will affect the quantum of damage, then character evidence will be administered. So if the character is to affect the quantum or the quantity of damage to be given, then this character evidence will be administered. So under criminal proceedings, evidence of good character can be allowed by a court. So someone is allowed to give evidence about his good traits and his good character, and it's based on the presumption of innocence until proven guilty. So someone can say how good he is, and he can be aided by witnesses who can call to help him prove to the court how good, or his moral standing, or how the public views this person. So you can say how good or claim how good his or his position in the society. So we have exemptions where bad character evidence can also be given under criminal proceedings. So you see that character evidence is allowed in criminal proceedings. So if the whole proceedings resolves around if bad character evidence resolves around the whole facts in issue, the whole proceeding, then bad character evidence can be allowed under criminal proceedings to be adduced. So also in a rebuttal, the prosecuting side is allowed to bring evidence of bad character against the accused person. So that's the two exemptions where character evidence can be administered in criminal proceedings. And under criminal proceedings, you have these two cases. This famous case of Maxwell versus DPP and the case of R versus Cook. And according to this case, for court to rely on the character evidence, this person must have been convicted on that character evidence, that earlier character evidence. Is based on the principle of double jeopardy, or the first acquit and the first convict, that someone is just protected from evidence being adduced against him or her, that he has not been convicted. So someone must have been convicted for this evidence to be produced against him. So in the case of Maxwell versus DPP, this is a case that involves the conduction of abortion. So a doctor did an abortion, and this doctor was claiming that he had that good character, he had that good moral standing. So the court ruled that in order to rely on this bad character evidence, this doctor must have served that sentence. He must have been convicted but not acquitted for that earlier offense to be brought bad character evidence. And the case of Maxwell is the case of R versus Coker. This is the case that Coker was being accused of breaking into a house. So Coker was claiming that he entered into that house for the purposes of comfort, just to seek comfort. So the court held that for Coker to serve or the bad character evidence to be produced against Coker, Coker must have been convicted for that early offense. Coker must have been convicted for that breaking into that house but not acquitted. So that evidence where Coker was earlier acquitted was not admissible because it was not convicted for that earlier offense that was being brought against him. And in the case of Maxwell versus DPP, someone just has that shield that protects him against bad character evidence, and someone can withdraw or throw away that shield that protects him from bad character evidence that to be adduced against him or her. So guys, that is all about character evidence, and it's just a general rule that character evidence is inadmissible in court, but we have exemptions where character evidence can be administered in court. So R versus Coker is a 1960 case, and I think that is the end of my lecture.